Hey, good afternoon, everyone. My name is Ani Pagosian, and I'm with the City of Glendale's Economic Development Team. Thank you all for joining us for our virtual Tech on Tap event today. It is my honor to introduce our guest speaker, Tom Lee, who brings a wealth of knowledge and expertise to our event today. Tom Lee is an associate at Troy Gold PC, and his practice focuses on representing entrepreneurs, emerging growth companies, and venture capital funds. Tom helps companies and their founders from the beginning stages of forming a company through successive rounds of venture financing and eventually in their exit events. Tom graduated from UCLA School of Law. We encourage you all to ask questions in our Q&A chat box after Tom's presentation. And Tom will lead the event.
Thanks so much for the kind intro, Annie, and thanks, City of Glendale for inviting me to share my experiences in this space. Like Annie said, I'm an attorney and I've been practicing for 8 years. I've been at my current firm, Troy Gold, for about 4 years. And my bread and butter is doing startup financing. And, I think when I think of startup financing specifically, it is venture capital, but it's also any other types of equity financing. So I think the type of person who will find this presentation most helpful would be, someone interested in starting a company at the early stages and wondering kind of what type of legal considerations do I as an entrepreneur have to consider, and what are my kind of paths to go down. I think most of the deals that I work on and we work on at the firm are venture capital financings. And these are typically, financings in the range of 7 or 8 figure financings with companies at valuations of 8 to 9 figures. So, that is the roadmap that I'm going to share here, and kind of what, VCs or sophisticated investors will often expect from a company that wants to be venture backed. But I think there's no one size fits all. There's, smaller companies, more bootstrap companies that will likely find this helpful as well, or I hope that you'll find this helpful as well. There's no kind of wrong way to do it, right? There are many successful companies operating at a smaller scale. And so there's, I just want to kind of preface that by saying this presentation will go down kind of a certain path that's more VC focused, but I think there might be something for everyone if you're interested in kind of the legal considerations of startup financing generally. So with that, we'll go ahead and get started. If this will switch, there we go. So I guess, a little about me. I'm at the law firm Troy Gold. I'm a senior associate there. We mostly do kind of emerging companies work, which is a fancy way of saying working with startups. And we do venture financing, like I mentioned. So by representing startups, we touch on the corporate side, helping them, form their company, go through rounds of financing. But we also touch on employment law, IP, commercial contracts, that kind of stuff. And I also do M&A, mergers and acquisitions, and I do some public company work as well. You can find us, feel free to visit our website. You can always shoot me an email. And our firm is based in Century City. We've been around about 50 years. We do litigation and corporate. And yeah, so just a little about me. And then wanted to share kind of the main key areas that I will be presenting on today. So we'll go through each one of these. And the last one is venture capital. And it's there because really this is kind of meant to be a checklist, if you will. Any VC, before they invest in your company, is going to make sure that all of these things, from entity choice to co-founder considerations to your first financing to what you've done to protect the company, they are going to look at that in the due diligence stage, in the legal due diligence stage. So really my goal here is kind of to share my experience. This is really just what we see on a number of deals. Since joining Troy Gould, I've done, over $200 million in financings. And, these deals kind of just always have the same issues, same roadmap. And if you're able to figure it out early on and make sure that you're set up correctly from a legal perspective, or at least aware of what the issues might be, you'll have a much smoother time when you do, raise your first Series C or Series A financing with a venture capital firm on the other side. So we'll go through each of these. And Annie, I don't know if it's, I know you have a Q&A session at the end, but I'd actually be open if people, as we go through, just have questions. I do kind of want this to be collaborative if possible. So
Sure, awesome.
yeah, so if you guys want to, as I go through, just drop a question in the chat box so that we can actually discuss something and make this a little more collaborative, I'm happy to do that as well.
Awesome.
So with that said, we will go. So, I mean, this is the first step, right? You're setting, you've kind of got an idea. You want to set up a company, and I don't know kind of the background of everyone who's joined. A lot of you might have or might be entrepreneurs with your own company already. A lot of you might just be thinking about this. A lot of you might have already raised multiple rounds of financing. So, this is really for those people who are just starting off and haven't even started a company yet. Like, how do I go about doing that from a legal perspective? And the number one thing that people always tend to ask is, what type of entity should I choose? The main ones that are kind of thrown out are LLCs, which are limited liability companies, corporations, and then within corporations, you can be either taxed as a C Corp or an S Corp. So really the choice is between being an LLC or a corporation. And, looking at this from like a venture capital institutional investor perspective, most of the time, if you want to be a venture-backed company, you have to be a corporation. And specifically, you have to be a C corporation. So as I go through down this list, I'll explain kind of why. That doesn't mean that LLCs are bad. In fact, LLCs are great for certain types of business models where you do not necessarily need venture investment, but where you might be getting investors that are angel investors or high net worth individuals or so on. So the main consideration here is actually tax driven. LLCs are what are called pass-through entities, pass-through tax entities, which means that whatever money or loss, whatever gain or loss the LLC makes in its business is passed through to the partners. In other words, it's passed through to you as the member of the LLC. That means that when you file your taxes, whatever income that you realize from the LLC, you're filing those taxes along with your personal taxes in the same tax form. It's called a K-1 that you file with your own taxes. So this is great for, and it also means that, any kind of gain the LLC recognizes, any sort of money that the LLC makes, you can just distribute that from the LLC to your own bank account, and it's just taxed like your own money. So say, the LLC makes $100, you own 50% of the company, you're taxed on that 50%. And you can distribute that directly to your bank account. And it's very frictionless, it's easy. People like LLCs because there's less setup. It's usually just an operating agreement. You don't have to go through a lot of corporate formalities like calling a board meeting or a shareholder meeting. And the downside, however, is because it is a pass-through entity, all of your, if there's an investor in your LLC, they are subject to those kind of pass-through rules as well on gain and loss, and they have to file K-1s on their own tax return. And if you're an institutional investor in the business of making investments, you are going to hate having to collect K-1s from every single one of your portfolio companies that's an LLC. And in addition, because a VC is structured as a pass-through entity as well, they're usually structured as an LLC or they're structured as a limited partnership. They have to then pass through that income to all of the funds investors as well, which they don't want that burden, and they don't want that headache. So a VC will never typically invest in an LLC. Now, LLCs are good if you're not trying to attract a VC, and it's good for more bootstrapped businesses, in my experience. For example, law firms or consulting firms, smaller businesses that like the flexibility are typically structured as pass-through entities, where the entity makes money and then they just distribute it off to the shareholders, or in this case, the members. But if and LLCs can still raise money, they can still have investors, but typically it'll be more along the lines of, high net worth individuals, family offices, those types of category of investors, and not institutional investors like VCs. So whenever you're making this choice between an LLC and a corporation, what we typically advise is for you to think about your business model and the scale of your business in order to decide. So, the typical business model and scale where you would need venture financing or venture investment, think along the lines of, like I said, financing rounds of 7 to 8 figures. What you want to achieve a valuation of, 50, 100 million, 500 million. If you want to go public, $1 billion. Those types of businesses need a lot of money. Let's put it that way. So those types of businesses are the ones that should be structured as a corporation to be able to take in venture investors and to be able to scale and have kind of the corporate organization that those types of investors expect. And then LLCs for startups specifically, those are more like, if you think you're just going to raise, a few million, maybe you just need like 1 or 2 rounds of financing to get off the ground, and then your business is going to be cash flow positive. And you like that flexibility, and you're not going to have a bunch of investors. In those types of situations, people do tend to like LLCs a little bit more because they're more flexible. And no matter what entity you end up choosing, we almost always recommend setting it up in Delaware. I think you can save on some, even if you're based in California. If you create a California LLC or a California corporation, it's not the end of the world. But the issue is California's Secretary of State, it takes a lot longer than Delaware to process just routine filings. And Delaware business law, the Delaware corporate code is a lot more business friendly. And so most investors would like you to be formed in Delaware. In fact, most of the venture financings we've done, if our client is structured as an LLC or even a California corporation, it becomes a closing condition that we help them convert into a Delaware corporation before they can take the money. And last but not least, don't use an S corp if you want to raise money. An S corp is just a corporation, but you make what's called a subchapter S election on your tax forms. The problem is when you do become an S corp, you cannot have corporate shareholders. You can only have individuals who are shareholders, and I think certain types of trusts. So again, S corps good for certain business models, right? If you're just a sole proprietor, or if you have like 2 or 3 partners, it's great for that. But if you want to raise capital, it's a little less flexible. So we would typically avoid that. Okay. So, we talked about entity choice, and we're still going down this roadmap of like, this new entrepreneur, this founder, they've decided, say, that they want to create a Delaware corporation, right, for their startup. Now that you're past that hurdle, the second hurdle really is like, how do I put this corporation together? What are the initial pieces for me to help form this corporation? And you probably have a co-founder, most likely. If you don't, that's fine. But this is really for those types of businesses where there is a co-founder or multiple co-founders. The most common question, very common question we get is like, how do I set this thing up? How do I split the equity amongst ourselves? Do we need a shareholders agreement? What kind of protections do I need to put in place to do this? And if you're not set up correctly, it's not the end of the world, but we have run into situations where, someone uses LegalZoom, or someone uses some other type of, software where they don't fully understand like what is being created. And it often results in higher costs to you if we have to go back as lawyers to fix something that an investor requires. Because remember, this whole roadmap is really, how do I get to actually being able to go through a round of venture financing with an investor and meet their due diligence and closing requirements. So co-founder considerations, it's all about staying together and what happens if you break up. I mean, that's really what it's all about. The initial equity allocation amongst yourselves that's purely like a business issue that you have to talk to your co-founder about. 60-40, 50-50. I mean, we're asked what we recommend all the time, and there's no formula. I mean, there's no clear-cut way. You just have to agree on something. Often it can be weighed in favor of like, okay, if whoever's put in more time, or if there's a co-founder who's put in more money, they should be the ones who get a few more shares. What I would say though here is, in my experience, 50-50 is not a great equity split. You end up in a deadlocked situation from a legal perspective. And if there is an issue, it's very hard to get out of. So if you have more than 2 co-founders, that's fun, that's great. Then you have like a tiebreaker. If you have 3 co-founders, I often see 3 co-founders split it, a third, a third, a third. And that way they need a 2/3 majority to approve as shareholders. So it's something you have to talk about, but don't do 50-50 in my experience, and weigh who is able to contribute more, whether that's capital, time, or assets to the business, to determine who should get more. Pretty self-explanatory there. And I think a lot of entrepreneurs don't understand the general kind of corporate governance, just basic corporate governance of a corporation. So you have shareholders and then you have the board. And when we talk about equity allocation and how many shares someone has, that's in your position as a shareholder. And the shareholders are the ones who elect the board. And so you not only have to figure out who are the shareholders and how the equity is split amongst the shareholders, you have to figure out who is on the board as well. And the board is the governing body that really controls the company and makes decisions for the company. So again, if you have a deadlock, 50-50 deadlock, and you're both on the board, if there is an issue, nothing's going to get done. If you are the majority shareholder, you can put both people on the board, and if something happens, you just have to know that the majority shareholder ends up controlling the board, so the majority shareholder can replace the minority shareholder on the board. Ultimately, that's how you determine who controls the company, is who is the majority shareholder. Majority shareholder determines the board. If the majority shareholder doesn't like you, they can remove you from the board. So I see a question here. How about a Nevada corporation? That's a good question. We do have some Nevada corporations as clients. Often we've seen some public company clients that are set up in Nevada. Nevada is a pretty business-friendly state, but I've never seen really like a venture-backed company being in Nevada. Venture capitalists, they kind of all act in concert in terms of what is standard. So that actually makes our job kind of easy in some ways. And I've almost always seen them only invest in Delaware corporations specifically. That being said, it's easy to convert to a Delaware corporation. We've done it a bunch of times. And if you do find a VC that's looking to invest in you, just have that conversation. My guess is they'll prefer that you convert to a Delaware corporation, but you never know. And again, like angel investors, family offices, high net worth individuals, they don't seem to care as much in terms of where you set up your entity. So we talked about corporate governance. So once you have that figured out, and once you're okay with who actually controls the company, the documentation in terms of your founder shares is pretty simple. Every law firm has their own forms. We have forms that investors recognize and want to see. So it's usually just a stock purchase agreement. These are your founder shares. And you want to do this as early as possible after you set up your corporation. You want to issue your shares as early as possible so that you can capture the lowest price possible. And so when people talk about founder shares, these are shares, per share that are worth like, we do 0.0001 cents per share. And you want to do that the moment you set up your company so that you can justify that extremely low price. And then after that, after successive rounds, after you grow, after successive rounds of financing, obviously your share price increases. But as a founder, you come in at the lowest price possible. And that's your sweat equity. That when people refer to sweat equity, that's what they're talking about. You're getting in at a nominal price. It's usually, founders end up paying like a few hundred to a few thousand for those shares that are worth 0.0001 per share. And then you're off to the races, right? Then you control a large portion of the company, and your goal from then on, besides having a great business, is increasing your share price from there. So the most important thing, one of the most important things, I think it's actually probably the most important thing amongst co-founders specifically, is to make sure that you have vesting and on your shares, on both of your shares. And so what do I mean by vesting? So vesting is the ability for the company to repurchase someone's shares if they leave. And it's repurchased at that extremely low price of 0.0001 or whatever they bought in at. Why is it important? So imagine you have 3 co-founders. You all have a third of the company. After you issue those shares, a month later, someone leaves. Someone says they're not interested in working for the startup anymore. Happens a lot, honestly. Working for a startup is hard. They should not be able to keep a third of the shares, obviously. And so, and investors know that, so they need to see vesting as well. That's the classic, free rider problem, is you don't want a free rider. No one wants a free rider. Everyone wants everyone incentivized to continue working for the company. So what vesting does is a certain amount of shares become vested over time. That time is normally 4 years. So over 4 years, your shares vest and can no longer be repurchased over those 4 years. And so if someone leaves, immediately, then they don't vest any shares. If someone leaves, in 2 years, then they'll vest, half of their shares. And that way it's a fair system so that people, all co-founders are incentivized to continue working for the company. And if someone leaves, then their shares are repurchased and they only get what they worked for, essentially. Okay, and so last thing here in terms of considerations, if you have vesting, you want to make sure you file what's called an 83B election within 30 days of receiving your shares that are subject to vesting. This is surprisingly forgotten by a lot of people, by a lot of lawyers as well. There's no great way to fix it if you miss this filing within 30 days. And what this filing does is it taxes you on your shares at the moment that it's issued to you instead of when it vests. So remember, we're issuing these shares at fractions of a penny per share. So you're happy to be taxed at that low price for those shares. It's worth nothing, so you're taxed at nothing. You have no tax obligation. If you don't file this, you're taxed when the shares vest. So usually vesting is like yearly or once in a year and then every month thereafter. Your share price, if your company is successful, your share price likely will have gone up by then. And then you actually still start having tax liability. So always try to remember to file an 83B election. Sometimes we have to get creative to try to fix this if it gets missed by some other law firm and we pick it up. But yeah, it's hard to fix. And one last thing here, people ask about kind of shareholder agreements and that kind of stuff initially. We typically don't see the need for a shareholder agreement. Assuming that thought has been put into, who the major shareholder is, who the controlling shareholder is, who's on the board, and people are aware of those risks, there's not really a great reason to set up a shareholders agreement that it doesn't really control for a lot of things that need to be controlled. Usually we have bylaws that we prepare that have, the standard kind of transfer restrictions and that kind of stuff. So we typically don't see shareholder agreements put in place amongst the co-founders. It's not really needed, in my experience, if you're set up correctly. Okay, moving along. So, again, this theoretical entrepreneur has been going through the steps. He's now set up the company with his co-founders, and the first thing you want to do, or one of the first things you want to do after setting up your company, is probably raising some money so that you can start building your product, right? Often that's your own money, but the main purpose often of having this type of corporate structure is to use other people's money. And that's just the facts. And you want investors to invest in you to help you grow. By doing so, you're giving away portions of your company, right? And when you do that, this is probably, so, I would have gotten a lawyer involved at the first stage. But if you're at this stage and you don't have a lawyer involved, you should definitely get a lawyer involved. Because raising money, you need a lawyer who understands securities laws. When you sell stock to an investor, or not even stock, if you're just selling any sort of security in your company, it either has to be registered with the SEC, the Securities and Exchange Commission, or you need to rely on what's called a securities exemption. And there are various securities exemptions. A startup is never going to register their shares with the SEC because it takes, hundreds of thousands of dollars in legal fees and legal work and stuff to do that. So they will instead find an exemption. And the most common exemption that we use is Rule 506B under Regulation D. And that is the accredited investor exemption. So as long as you are selling your securities in your company to accredited investors, and there are rules determining who an accredited investor is, it's typically someone making over a certain amount of net worth or having a certain amount of net worth. Or it's like an investment company or an investment fund. And so as long as you're selling it to those people and you make kind of certain notice filings, you can raise money without registering with the SEC. So that's typically the stage where you need someone who knows these types of laws to help guide you. And once you have that set, and once what type of people you're allowed to go out to get investment from, what is the typical kind of legal documentation that we need to do that? We almost always nowadays, for our startup clients, everyone typically uses what's called a SAFE. A SAFE for their first financing, for their first money in. And a SAFE is a simple agreement. It stands for Simple Agreement for Future Equity. And it's like, I don't know, like a 5-page document. It's something that the accelerator incubator Y Combinator created. And it's a very, very simple way to raise money from accredited investors because it's a form that everyone recognizes, and they just put in the investment amount and what's called a valuation cap. And so the way that these things work, without getting too into the weeds, because I think I don't think we need to talk about every single term, but the way they work is an investor it gives you money now with the promise that when you do raise your future round of preferred stock or stock financing from a VC, that their SAFE is going to convert in that round. And it usually converts at some sort of discount because they put in their money first. And that discount is in the form of usually a percentage sometimes, or it's in the form of what's called a valuation cap. So a valuation cap would be like, let's say 10 million. And if in the future round, you raise money at a 20 million valuation, because someone gave you a SAFE for 10 million valuation cap, you basically get those future shares at half the price. Simplifying a bit, but that's typically how it works. So SAFE's really easy to use. It's very short compared to other types of preferred financing documents. And everyone uses them, frankly, for their first round of financing. And I think what we've noticed is this has some downsides because it's so easy to use. Some of our entrepreneurs, don't put too much thought into them. It's literally you're just changing some numbers and sending it out. If you have a hot startup, or if you're good at selling your startup, you're not putting too much thought in them, and you're typically not running it by your lawyers every time you do this. So often, what you got to be careful with is you have to really understand how the valuation cap works and how you're diluting yourself in the future when you issue safes. And if you issue too many safes, it seems fine at first, but just know that all of those safes will eventually convert into stock in your future round. And that means you'll all of a sudden have a ton of stockholders and you'll have a ton of dilution in your future round. So it's something that you got to think about. Most of our entrepreneurs ask us to model out for them. Okay, how much am I diluting myself if I sell this many safes? Assuming I raise X amount in the future in a preferred financing. So great tool. We recommend all our startups use safes, but there's just some things to really think about. Okay, SRAM has a couple questions. Thanks for your questions. What are high-level negotiable tips you would suggest when lenders insert warrants and covenants? Yeah, that's a good question. Lenders typically will almost always want to take some sort of warrant out, depending on how much money they're putting in. So usually it's like a percentage of the debt. For startups specifically, like warrants are just how lenders who make venture loans, that's just how they capture upside. So you're never going to get out of it's very rare that you're going to get out of being able to give them a warrant. But it's what you can do is you can just try to negotiate the amount of warrants down. I think that's really just a business discussion that you have to have with them. Covenants, I find that that's very hard to change. You need, I assume, any sort of negotiation you're doing with a bank, with a lender, you're using an attorney. And so, attorneys will try to kind of negotiate around the edges and kind of advise you on what's market standard. So I would try to make sure that you have a good attorney that understands debt financing to help you with those types of issues. And you also had a question about most favored nations. No, most favored nations are not good for the company. So what SRAM is referencing here, a most favored nations clause in a safe is something along the lines of you're promising the investor that if you give someone a safe with more favorable terms, that you have to then give this investor with the most favored nation clause the same better terms. You have to amend your current agreement to give them better terms. Sophisticated angel investors who understand the safe will often ask for those. I highly recommend pushing back on that strongly. You lose a lot of flexibility if you do that, because I think, again, safes are so easy to use. Some entrepreneurs will come out of the gates really hot. They have great pitches, and they'll just set an enormous valuation cap that is not justifiable, right? Like something high like 25 million when you don't even have a product. and someone will inevitably sign that. I mean, so you'll get someone to give you some money based on that. But often, you know, after some time, you can't justify your valuation, or you can't justify that valuation cap. So then, you know, we've seen situations where an entrepreneur a company has to just issue safes in the future at a much lower valuation cap. Well, if the first guy has a most favored nations clause, or all of the investors in the first round have a most favored nations clause, they can now switch all of their safes down to the lower valuation cap because of that most favored nations clause. And you know, you can try to ask them to waive that or not do that, but at that point in time, you have no choice often. And you know, it becomes a very difficult decision as to what to do. So yeah, we if we're representing the company, we almost always try to get rid of the most favored nations clause.
Thanks, Tom. Appreciate it.
Yep. Okay. Why don't we keep moving? I think we're kind of running short on time, so I'm going to fly through a bit here. Okay, so you've used safes to raise your first round, your initial round, and you're starting to grow, right? You have to show some growth before a VC decides to invest in you. You have to validate your business model. You probably have to hire some people. So what do we usually see when a startup starts to do that? They'll come to us asking us to put together an equity incentive plan for them. And what that is it's a plan that lets the company grant stock options or restricted stock to new employees or new consultants. Because you're going to hire people, they know you're a startup, they know you're a hot flying startup, so they're going to want some equity. And you need an attorney that understands equity incentive plans and understands how to set those up and how stock options work and how that dilutes you guys as the founders when you set up that plan, to help you walk you through that. You know, so that's number one. And number two, you know, I think all startups, when they start growing, besides corporate law, which is what I've been talking about this whole time, they need two other types of lawyers or people knowledgeable in two other types of law. And that's IP and employment law. Those are kind of key. And so IP protection, this is when you really need to start thinking about what type of IP do I have? Hopefully at this point, any IP that the founders had previously before forming this company has been contributed to the company. And everyone, if you have a company that has high value IP and that's like where your value sits at for your company, everyone in your company has to sign some sort of agreement where they assign any IP that they create to the company. Typically that's called an inventions assignment agreement. For contractors or consultants, there's typically that clause is typically built in to their consulting agreements, or should be. And really that's something that all VCs during their due diligence process will look for, to make sure you have those agreements signed. And kind of flowing into that, you know, startups have very basic offer letters. That's totally fine. You just have an offer letter. California is an at-will state, but you should have a good employment attorney on speed dial as needed, because you're going to be setting up, you know, your payroll. You're going to have questions. You're going to be setting up. You're going to have questions about, you know, who constitutes an employee versus a contractor, right? And those are kind of legal considerations you should talk to an employment attorney about, because as we all know, California is a very employment litigious state. People get sued all the time by their employees for not following the myriad of California wage and hour laws. So you want to make sure that you at least talk to someone, understand how those things work. Don't have time to do that on the call, but you know, make sure you do that, and make sure you get insurance, business insurance. Okay, so wrapping up here, I think if you've done all of those things on this slide, those are the things that VCs really look for. And so once you've done all that, once you've grown, once you've pitched VCs, you're ready for what's called your preferred financing. And so these are not safes. This is think of your real round of financing where you're going to get a term sheet from an institutional investor, right? A big venture capital firm. This is who you're pitching, and these are the guys that are looking for the next billion-dollar company. And so when you start approaching these guys, and when you get into this process, this is often the first time that you're going to be working on a fast-paced, large, relatively large legal transaction, business transaction with a bunch of legal documents. So things to think about, like you have to understand what is in a venture capital financing term sheet, and you have to rely on your lawyers to guide you through that. So main things, right? What is my valuation? But within that, understand what is your pre-money valuation and what is your post-money valuation. Is the stock option pool included in the pre-money valuation or the post-money? And are all the safes that I've issued, are they counted in the pre-money or are they counted in the post-money? All those things have to be negotiated and set forth in the term sheet. These types of financings are for what's called preferred stock. It's often the first time that you're going to be issuing new shares outside of the founder shares that we talked about. And so these guys are shareholders now. They're becoming shareholders, and they're becoming preferred shareholders of your company. These shares have rights that are frankly going to be better than your rights from a economic perspective. You are going to hold common stock, and they will hold preferred stock. That means their money gets out first, often when there's an exit event. That means they have certain veto powers, where if you want to do something as a company, it has to go through a vote of the preferred shareholders for you to do so. And a myriad of other investor rights. So really understanding that and having a lawyer help walk you through what those things mean, I think becomes really helpful. And then we draft the financing docs. And frankly, as an attorney, I don't expect all my clients to read through every single financing document. There are 5 main financing documents and a bunch of ancillary documents. We don't expect you to read every word, but what we hope to do, and what you should do once you get to this stage, is understand the big picture terms in the term sheet. Make sure you can find those, at least, in the financing documents, and just keep track as the 2 law firms trade drafts back and forth, right? Just keep track of what's going on. You don't have to read every word, but the law firms are going to generate red lines so you can see what was changed, and just watch the back and forth and try to understand what's going on, and understand your cap table and how the safes convert and how the money dilutes you. And from there, I think if you understand all those things, and if you've checked all the boxes that I've said before, those are really the things that the VCs are looking for in their due diligence. Making sure that the founder shares have been properly issued, making sure you filed an 83B election, basic stuff like making sure that all your employees have signed inventions assignment agreements. If you have all that lined up for us, or if we've already done that for you, it's going to make the financing so much easier, and it's going to save you legal fees. Okay. So I think Annie, I think that's all I have for now. Yeah, I know that we have running short on time, so I'll stop there and see if there's any questions.
Awesome. Yes. So feel free to add your questions in the chat box. Okay, and I just wanted to announce, please save the date for Glendale Tech Week, which will be taking place September 12th through the 14th. And more information can be found online at glendaletechweek.com, and I will enter the website on our, in the chat box. This session is recorded and you can find it on our Glendale Tech on Tap webpage, which I will also include in the chat. I don't think there are any more questions. If not, we
Okay.
will conclude the session. Thank you so much, Tom, for such an informative presentation. Oh, we do have a question. Okay, go ahead. As a law firm, which VC debt partners do you work with? Are they banks or private credit?
Yeah, so we actually don't. So we don't work directly with. We don't represent any venture debt firms. We've worked across from some. I think, right now, some names that pop into my mind are, I think there's a company called WTI. I forget what WTI stands for, but we're working on a deal across from them right now. We don't deal with venture debt too much. I mean, obviously, as you know, Silicon Valley Bank was a big player in venture debt, but they're still going. Actually, I have a client that has a warehouse loan with Silicon Valley Bank. They're just, they've been acquired by another bank. So, but they're still operating. Yeah. So we don't. If I'm understanding your question correctly, we don't represent any. Our firm doesn't represent any venture debt banks. The ones I've seen are usually banks, are structured as banks. I've seen some venture debt funds as well. I can't say which ones are more common or not, but yeah, I mean, they still exist. They're still out there. They're still doing stuff. So.
Cool. Thank you.
Okay.
Great.
Well, thanks so much, everyone. I really appreciate, the time and letting me share my experience. If you have any other questions, my contact info is right there, and our website is right there. Feel free to reach out to me. I know that this was a very broad scope, and like I said, there's no one size fits all. My bread and butter is kind of venture capital financings, but we do a ton of other types of financings as well, equity financings as well. So, if you ever have any questions, we're available to discuss.
Awesome. Thank you so much, Tom. And thank you all for joining us for this wonderful event today. Have a great rest of your afternoon and evening.
Great.
Okay.
Thanks so
Bye-bye.
much. Bye.